Chief Justice and Associate Justice, and may it please the court, I, Lance Belderol, along with my co-counsel, Bryssa Rodriguez, are here to represent not only Mr. Tyson Timms, but we are here to defend liberty itself. I am reminded of Senator Barry Goldwater's 1964 speech when he said, "I would remind you that extremism in the defense of liberty is no vice. And let me remind you also that moderation in the pursuit of justice is no virtue." Now, this case is simply the use of the police powers of the state. Our client pled guilty to selling $400 worth of drugs to an undercover agent. He received his fine, he received his sentence, and he was okay with paying his debt to society. However, the state crossed a line when they, under civil action, sued to take his Land Rover, which he purchased out of the life insurance money that was left to him by his father. The loss of the car was over 10 times as valuable as the drugs sold, and it is clear that this was done as punishment against my client. This wholly is an unjust loss of liberty, not only for my client, but for everyone in the United States.
Sir, why is it a loss of liberty?
Simply because you're infringing upon the right of people to have property. And bridging into this is clearly something that our founding fathers were trying to protect us against: excessive fines. As Thomas Jefferson had once stated to Samuel Kercheval, "The true foundation of Republican government is the equal right of every citizen in his person and property and in their management." The excessive fine the state has issued onto our client affects the fabric of not only our Constitution, but also paves a dangerous and thorny path into further case proceedings.
Why would this be excessive?
Simply because they already had him. They already had him under jail, and he already paid his dues. He'd already paid and been accepting of his debt to society. However, the car that he had, they had decided simply to take it over. He bought that with his own money, and everything that was done to him by the state was already done. However, they decided to take it and cross the line and simply take his property as well. Now, this sentiment echoes throughout history, for again, as Thomas Jefferson had stated to Isaac H. Tiffany, the rights of the people to the exercise and fruits of their own industry can never be protected against the selfishness of rulers not subject to their control at short periods. Clearly, Jefferson believed in the right to procure property and to use it for one's own enjoyment. This very right is essential to the freedom of every person, and our other rights would mean little without these rights of property ownership. If this is the case, how can the government take away something that was legally yours? He's paid his dues and he's done everything. The state simply crossed the line. In the end, Barry Goldwater had said it best: "Those who seek absolute power, even though they seek it to do what they regard as good, are simply demanding the right to enforce their own version of heaven on earth." And let me remind you, they are the very ones who always create the most hellish tyrannies. Absolute power does corrupt, and those who seek it must be suspect and must be opposed. And if there are no further questions, I will retire and let my co-counsel speak.
Good morning, Chief Justice, Associate Justice. May it please the court, I, Bryssa Rodriguez, will be presenting 3 arguments, Your Honor, that will demonstrate why the 8th Amendment's excessive fines clause should be incorporated only through the Privileges and Immunities Clause of the 14th Amendment. We resoundly and firmly disagree with the Indiana Supreme Court's ruling, and we respectfully ask that you overturn this ruling for the following reasons. First, precedent is not sufficient to justify the infringement of citizens' rights. Second, the 10th Amendment does not supersede the 8th Amendment. And third, property is a fundamental right that has been defined and granted protection. So to our first argument, Your Honor, precedent is not sufficient to justify the infringement of citizens' rights. As my co-counsel has effectively argued earlier, the application of amendments to state has always been a topic of controversy, but was first outlined in the infamous slaughterhouse cases in 1873. Now, the rulings were significant because the Supreme Court interpreted the scope of the 14th Amendment and its application. When reviewing the case, the court maintained a lot of focus on the argument presented by the plaintiff, whose assumption was that the citizenship, privileges, and immunities guaranteed by the Due Process Clause of the 14th Amendment were all the same. However, Your Honor, Justice Samuel Miller expressed a distinction between Article 4 and the 14th Amendment and declared that Article 4 protects the rights of the state citizenship and the 14th Amendment protects the rights of national citizenship. So this left a lot of question in the air over which rights were constitutionally protected and which were up for the state to decide. These answers, Your Honor, were found in Corfield v. Corio, 1823. The court understood that it had to analyze the Privileges and Immunities Clause and interpret what was protected and considered property. And the court said to this, Your Honor, protection by the government, the enjoyment of life and liberty with the right to acquire and possess the property of every kind and to pursue and obtain happiness and safety, subject nevertheless to such restraints as the government may justly prescribe for the general good of the whole. This became the precedent for the protection of our fundamental right to property. The next time a court made a major decision was in Chicago v. Arco versus Chicago in 1897. 1897, Your Honor, long before the court began to focus on selective incorporation of the Bill of Rights through the Due Process Clause of the 14th Amendment. The precedent expressed a need for strict interpretation for the application to be valid. And similar to this finding was the court's decision in U.S. v. Halper, 1899. So, in the past, Your Honor, the Supreme Court has specified that the Bill of Rights protections can apply to defendants in purely civil proceedings when the government
Counselor,
is the plaintiff. Yes, Your Honor.
If we decide to take the other side and say that states' rights are greater than individual rights, what would happen?
Well, Your Honor, not only would you be taking away the rights of citizens, but also you would be creating a police state that would allow the state to hold authority over even federal statutes, and that's not something that we should allow for the state to do.
Okay, continue.
Now, while the issue focused on a whole different amendment in the Halper case, it is important to know how Halper looked at the case. The Halper case is important because it established the precedent in the Bill of Rights protections to be applicable when addressing forfeiture. In U.S. States versus Milburn in 1995, the court acknowledged that Halper was applicable to civil forfeitures, but that the punitive element must be determined in a case-by-case analysis. That is the same standard that we should adopt today, Your Honor. The state contends that because there hasn't been a decision to prevent it from overstepping its boundaries, then that there shouldn't be a problem. However, there are many problems here. Just because you can do something doesn't mean that it's the right thing to do.
Counselor, what do you mean by that?
Well, Your Honor, the state contends that because there aren't any specific restrictions that basically don't allow them to take property or that don't allow civil forfeiture or view it as punitive, then that for that reason it shouldn't be considered punitive.
Now, Counselor, I heard somewhere maybe that you do something for good of society, let's say. Is it really good for society if you commit a crime that's worth about $400 to take $40,000 from you?
So, yes, Your Honor, to that question we'd like to answer and again cross-apply the Coriol case in which the court acknowledged and said that property is a fundamental right, and by doing so they protected property, and the state understands that, but they continue to do so because there hasn't been a specific case that doesn't allow them that. So if, in response to your question, Your Honor, property is a fundamental right, and it's a right that shouldn't be messed with.
Well, if that stands to reason, then if you did $400 worth of selling drugs or whatever, and then you paid your $400, what good would it be to society to forfeit $42,000 worth of property?
Well, with what we're arguing today, Your Honor, is that there is no good or benefit that society is gaining from obtaining more than what was already paid. And for that reason, we ask that this court reevaluate the decision made by the Indiana Supreme Court.
It would be your assertion even that not only is no good, you're actually doing harm, correct?
Harm to the individual as well as the rights of other citizens.
Continue.
To our second argument, the 10th Amendment does not supersede the 8th Amendment. The incorporation doctrine has been used on several occasions to ensure the rights granted to us by the Constitution and made applicable and protected. So much so that only that all but only 2 amendments from the Bill of Rights have been incorporated, those being the 9th and the 10th Amendment. And sure, the state can try to argue that the ones that have been incorporated haven't been incorporated completely.
Counselor,
Yes, Your
why
Honor.
couldn't the 10th Amendment be incorporated?
Simply for the reason, Your Honor, that the state should not have the power to exercise control over federal matters and
If they
matters
did,
of
what
federal
would-
jurisdiction.
Ostensibly, what would be the worth of the Constitution if they could do that?
The Constitution would lose all its value. The whole purpose of having the Constitution and having the Bill of Rights is to ensure that the state doesn't have that power.
So it would be your assertion if the court here decided today in favor of the state of Indiana that actually what would happen to our Constitution?
It would be torn apart, Your Honor. In-rim forfeitures, Your Honor, are a blatant abuse of authority that completely tear apart, again, the original intent of the framers when writing the Constitution. In Browning Ferris Industries versus Calco Disposal, 1889, the Supreme Court ruled that the 8th Amendment's prohibition of unreasonable fines does not apply to punitive damage awards in civil cases when the U.S. is not a party. Now, before reaching that conclusion, the court did express concern over the amount of power the government could hold in cases alike. And just a year earlier, the court in U.S. versus Tax Law 1988 said that the legal niceties, such as in rem and in persona, mean little to individuals faced with losing important and or valuable assets. So to this, we'd like to respond that this is more than just a valuable or a personal asset. We're talking about a fundamental right. Essentially, the court understood the significance the decision could have in future cases and were very uncomfortable with the idea of the state holding this amount of power because it could lead to cases like the one that we find ourselves in today. So it is very important to note, Your Honor, that there is a significant difference in our case today. As the court clarified in Browning Ferris, the 8th Amendment's excessive fines clause was inapplicable because the U.S. was not a party. Today, the Supreme Court has the opportunity to involve the U.S. as a party directly and ensure that all of the citizens' rights are protected. And we shouldn't allow for the state to get its way and continue to abuse their power.
And Consul, are you saying just because the United States isn't involved in the suit, but here the United States is involved because they have protection of the Constitution, correct?
Yes, Your Honor, that is our contention today. So, to that, Your Honor, in this time, it brings us back to the original question. Should the 8th Amendment's excessive fines clause be incorporated against the states under the 14th Amendment? The court from Browning Ferris would say yes, Your Honor, and this court should do the same. The Privileges or Immunities Clause of the 14th Amendment is very clear when it says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, meaning that whenever a citizen's rights are at large jeopardy because of the state, the court must uphold the citizen's fundamental rights. To our third and final argument, property is a fundamental right that has been defined and granted protection. Your Honor, the case at hand today is much bigger than just protection from an excessive fine. Mr. Tim's property rights are being completely trampled over, and this could be the case for citizens if they were to find themselves in this very same situation. In the past, the court has opted not to weigh in on the value of the asset of the thing being seized compared to the gravity of the offense charged, and the state believes that it is its strongest argument because there is a lack of precedent, and the court's similar rulings in the past are what should be upheld. But Your Honor, they were very different circumstances. And again, cross-applying the Halper case, we must look at each case to evaluate the punitive damage on a case-by-case analysis.
Counselor, why would it be important to find out the gravity of the crime versus the forfeiture?
Well, Your Honor, normally one would say to determine whether or not it was excessive. And because precedent and other cases have said that that's not important, we bring the point to court that if that's not the case, then we should look at the punitive element.
Okay. For a hypothetical question, Counselor, let's say that somebody committed a crime that was a $1,000 fine, and then you gave them $1,100 fine instead of $1,000. Is that excessive? $100 more?
Yes, Your Honor. We would find it to be excessive because clearly there's an outline about how much would the person that is guilty of that offense they would have to pay.
Okay, so if you thought a little could be offensive, then maybe 10 times would be grossly offensive.
Right,
correct?
above and beyond, right.
Continue.
So Article 4 and its privileges or immunities clause was included by Hamilton to ensure that the fundamental rights of all citizens across the country were protected regardless of their location, whether it be permanent or temporary. And herein lies the problem, Your Honor. There was no need to take that additional measure against Mr. Timms when he had already complied with the punishment the court had decided. Forfeiture, Your Honor, has been defined by Black's Law Dictionary as an involuntary relinquishment of money or property as a consequence of a breach or non-performance of some legal obligation or the commission of a crime. Your Honor, there was no need to have the civil forfeiture suit. A consequence, Your Honor, is a punishment, and so therefore we ask that you see it as that.
Counselor, in that light, I may ask a few questions. Was the Land Rover used in the commission of a crime?
Well, yes, Your Honor, but a crime that he had already served time for.
Okay, but I mean, were the proceeds that bought the car, were they from any criminal?
No, Your Honor. Actually, the car was bought with life insurance money that was given to him by
Why
his
is that important in this
father
case?
that passed away. Well, because usually that's how they would tie or how they would justify the taking of an asset, if it was vinculated with a crime or if it was paid with crime money. And in this case, that's not what happened. What happened was that he happened to be driving the car after the police set up the two sales, and that's when they were able to catch him.
And a question on the time frame. He had already gone through the criminal procedure before they started the civil procedure, correct?
Right, Your Honor, and it's important to note that his guilt is not in question today, but rather his rights and the abridgment of those rights. And so for that reason, while he had already pled guilty, he also served time for his plea, and there was no real reason that would benefit society in taking the car, if that makes sense.
Continue.
So the government seizing Mr. Timms' property is not only plain theft, but it is a clear infringement of his Fifth Amendment rights that protect him from double jeopardy. And unlike other cases...
And Counselor, could you
Yes.
explain that a little bit more? How could that be double jeopardy?
Well, again, Your Honor, when it comes to the discussion of whether or not he had already served his sentence, Mr. Timms did pay an amount of money that was settled in court after he pled guilty, and there was no real reason why the police should, again, take a car that was seized over a crime that he already served time for.
Would it be your assertion that he paid for it once and now he's had to pay for it again, so therefore that would be double jeopardy?
Right, Your Honor. May I proceed?
Yes.
So, unlike other cases where there is an issue of material fact to address, Mr. Timms' case is quite simple. The court in Austin v. U.S. 1993 ruled that the fine imposed in the case was indeed punitive and followed the reasoning in the Browning-Ferris case, as we addressed earlier. And to that, they also included Leonard v. Texas in 2017, in which the court in that case made notice of the lack of specificity within the Eighth Amendment itself. And the Eighth Amendment, Your Honor, says that excessive bail shall not be required, excessive fine shall not be imposed, and cruel and unusual punishment shall not be inflicted, and all penalties should be proportioned to the nature of the offense. And the court in Austin 1993 made sure to clarify the lack of specification in terms of constitutional protection do not limit it to justify the actions of criminal nature. So the court in Austin understood that one doesn't have to be in criminal court to be subject to punishment. It reviewed the case and interpreted it through the analysis of the Eighth Amendment's history, and ultimately determined that the seizure of property is and has always been considered punitive. So the government is ultimately left with a very heavy burden to prove today, Your Honor. They must prove that the property seized is malicious in nature and that it had to be taken for the well-being of society. And they can't, Your Honor. It's a car. It cannot have malicious intentions. Property, Your Honor, is a fundamental right that the government should not and cannot intrude upon unless we allow that to be the case today. Thomas Jefferson wrote once in a letter to Samuel Kercheval, "A right to property is founded in our natural wants, in the means with which we are endowed to satisfy these wants, and the right to what we acquire by those means without violating the similar rights of other sensible things." Much of what was an issue in the past is not an issue today. Mr. Timms' Range Rover was not violating anyone's rights and was not making society a worse place. The state did not have a reason to take away Mr. Timms' property. The key focus of this case is property, and for those reasons, The excessive fines clause should only be incorporated through the privileges and immunities clause. Property is not only a privilege and an immunity, but it is also a fundamental right. To incorporate the Eighth Amendment through the Due Process Clause would only open the door for the government and the state to take advantage of definitional technicalities to continue to deprive citizens of their rights. Let's not allow this to be the case any longer, Your Honor. In essence, if this lower court ruling is not overturned, this court will have established a precedent of a police state. This goes against the ideas expressed in the Declaration of Independence, liberty as well as right granted in the Bill of Rights, first freedom of speech, Fifth Amendment double jeopardy, and the Eighth Amendment excessive fines clause. If there are no further questions, Your Honor, I will retire. Thank you.